Hello and welcome back to Let's Talk Title with Emerald Coast Title Services. I'm president of ECTS and host Dion Moniz, and
I'm Ashley Bowen, a licensed title agent and the director of operations here for Emerald Coast Title Services.
All right, so today we're here to talk to you about the new law that Florida enacted actually back on July 1 that addresses these right to list agreements.
So this is a lien that is placed on the property, and it's prohibiting sellers from selling the property. I was told about this last year, and I thought, good to know, but it's never going to affect us here in Okaloosa or Walton counties, and it is. We just got one on a closing for a property in Crestview. There's one of these liens on it, and so we had to dig in.
So the biggest offender, and I think the reason this law was created was because of there's litigation out there now. The state attorney has sued. It's MV Realty. They're in Florida. They're in 33 other states, and they're being sued by 7 different states, including Florida. But it's over their homeowner benefit program. And so ultimately what it is when you, I'll let you explain.
Okay, so what they would do is this MV Realty company would go to homeowners, typically elderly homeowners, and they would say, I'm going to give you $1,000 right now, and then you're just going to sign this document that says whenever you sell your house, you'll list it with us and let my company sell it for you.
Yep.
And so these homeowners were signing these agreements, and then the MV Realty company was then recording them, and when sellers went to list their property, this lien would come up on the title search, and they would say, well, we're not going to list it, but you have to pay us like $40,000 at closing to remove the lien.
Yep, exactly. So the owner gets paid anywhere from $500 to $5,000 based on articles I've read. And what the owner doesn't understand is that agreement has a 40-year term on it.
40 years.
So it basically says if you sell your house anytime within 40 years, you have to list it with us. And if you don't, you're going to pay a steep penalty. And oh, by the way, this creates a lien on your house. And then they're recording those agreements because there's an Exhibit A to the agreement that says you agree to let this serve as a lien, blah, blah, blah. And so, yeah, they're recording them, and they're coming up on title searches now. 20 years later, the owner goes to sell, completely forgot about this homeowner benefit program they signed. Lien pops up, and now MV Realty is actually enforcing the agreements. They've filed lawsuits against homeowners and tried to foreclose the lien.
Oh.
And so, yeah, so it's a big risk to owners that are under these agreements. But the state attorney has filed suit declaring them invalid and deceptive and unfair and deceptive trade practices. And so ultimately, the 7 states so far, they're trying to get these invalidated completely. And for anyone who has fallen victim, try to get that money reimbursed. But as a result of these lawsuits, MV Realty's filed for bankruptcy. Now it's Chapter 11, which basically means they get the ability to it's almost like a reorganization. So they're not going to get out completely, which means the homeowners aren't released from these agreements. MV Realty is trying to buy more time to pay these owners if they are declared invalid. So they're trying to hide behind bankruptcy. But people who are under one of these agreements with MV Realty, you need to understand that MV Realty is filing suits to enforce them, so you're not necessarily going to get out of it.
Not yet. And
without paying the fee.
And this this new law that was enacted in July 1st of 23,
yep,
that will prohibit future agreements such as this, but those that were filed prior to July 1st of 23, those liens are still they're still active liens, and we still have to get them cleared.
Right.
This one that we found on the Crestview property was recorded in September of 22, so it was not very long ago.
Yeah, and in our situation, the owner has reached out to MV Realty, and sure enough, they're not letting him out. They're saying, all right, we'll cancel, but you have to pay the fee, or let us sell the property so they can make their commission. So despite all the lawsuits against MV Realty by the various states, and despite them filing for bankruptcy, they're still actively trying to enforce these agreements.
When we're going to be seeing more of them, I think. So everybody be aware, this is what it is.
So yeah, I think one of the articles I read says MV Realty has more than 30,000 customers in 33 states, and they've got approximately 400 million in benefits coming to them through these agreements.
Wow.
Assuming they all stick.
Uh-huh.
So, and apparently there's been a lot of activity recently in North Florida, which is our area. So be aware of that. So what Florida has done in response to that is they created statute 475.279 that went into effect July 1 of 23. And so it only applies going forward. So if there are any of these right to list agreements that are entered July 1 or later, they have to meet a series of requirements or criteria under the statute. Otherwise, they're deemed invalid and unenforceable and in violation of the Florida Unfair and Deceptive Trade Practices Act. So what we'll do is we're going to tell you what the new requirements are for these right to list agreements so that you know what to look for. I say don't sign one, period. Mm-hmm. They're just bad.
You definitely have a real estate attorney look over anything before you sign it when it has to do with your property.
Yes, exactly. So if someone's offering you money to say, hey, I'm going to pay you $5,000 now in exchange for you let me sell your property later, that should be a huge red flag. Let someone look at it, a lawyer look at it before you sign it, please. But anyway, Florida's trying to look out for you, and so the new law that is now in place, they are actually calling it a residential loan alternative agreement.
Which kind of makes sense because it is kind of like a loan on your property.
Yep, exactly. And so what they define that as is a signed writing or signed written legal instrument or contract between a person and a seller or an owner of residential real property, which, number one, grants an exclusive right to a person to act as broker for the disposition of the property. Number two, has an effective duration of more than 2 years. Number three, requires monetary compensation to the seller or owner. And that's it. So there's three factors that have to be met for it to be considered a residential loan alternative agreement.
And for it to be valid. And like mine, it says that date is 40 years from the date of this agreement. So yeah, ours would not fall under.
Well, so these three criteria is what helps identify one of these agreements. So the MV Realty stuff would trigger because it's an exclusive right for 40 years, so definitely in excess of 2, and requires monetary compensation. So what happens then is now you go, okay, if you figure out whether the document is identified or qualifies as a residential loan alternative agreement, and if it does, then you get into the requirements. And so if you have one of those, in order for it to be legal, the agreement cannot be considered a lien. So you can't have any of the language that the MV Realty program has where it says, hey, you agree to let this be a lien on the property. So that's the first big no-no. Can't constitute a lien on the property. It may not be assigned. It's void if the listing services do not begin within 90 days after execution of the agreement. So effectively, it has to be implemented immediately.
Okay, and that is what most of these things didn't do because the MV Realty, in most part, gave money and then walked away.
Yeah, and so like in our situation, our owner or seller signs their agreement with MV Realty years ago. Mm-hmm. And so in this situation, that would be invalid because the listing services have to go into effect immediately. So it's meant to take into account someone who's ready to sell their house right then or within 90 days. Then if it goes into effect immediately or within 90 days, it's okay. The other requirements are it cannot be recorded. Again, keeping it from creating an encumbrance on the property. And, that's it. So there's those 4 requirements. And if all of those requirements aren't met, it's invalid.
Okay.
So good stuff. I'm glad that Florida did this. Hopefully the state attorney's lawsuit will prevail. By the way, MV Realty filed a motion to dismiss, which was denied. So the lawsuit is sticking, and I expect that these agreements are going to be declared invalid, at least in Florida. I think other states will follow suit. So for any of you that are under those agreements, hang in there. Hopefully the Florida lawsuit will come to an end soon, and you can be freed of those agreements. In the meantime, if you're trying to sell your property right now and you're under one of these agreements, you've got to make the decision on whether you want to fight it or just let them list it and let them get the commission and you not have to pay the penalty. Otherwise, it appears they will pursue the lien that's been created.
And here within the next 60 days or so, we should know what the process looks like of getting one of these liens released, because I think we're about to start that on this property.
Yep, exactly. All right, so hopefully you learned a little bit about what MV Realty's been up to and the status of that litigation, and what Florida has done to counteract those agreements, and how they can be invalidated under the law. So
we've had some great legislation come out in the last 3 or 4 years. It's a shame that our governor's stopped his bid for the presidential race, but that means we get to keep him here in Florida for a few more years.
Exactly, to create more good laws like this.
Yes, good for him.
All right, so as always, if you have any questions or need more information about this topic, feel free to reach out to us. Please also check out all the various social media pages that we have and our different podcast channels. So until then, we'll see you next time. All right, bye-bye.
Thank you, bye.